This is Rangu Satish. I'm the co-founder of Legal Adept. I have been practicing as an advocate in Supreme Court and in various high courts of various states. So today we are going to discuss a very important legislation, that is Prevention of Sexual Harassment of Women at Workplace Act 2013. You can ask me, why do we need to discuss it? Why do we need to understand this act? According to the recent survey, 81% of the women are subjected to sexual harassment at workplace. So do 43% of the men. So in the 21st century, women has been the forefront of the workforce, and they are aspiring to take the country to the greater heights. And women have been working in a very hostile environment as per the recent surveys, where 81%, which is a majority percent, almost three-fourth of the percentage. So here we need to understand the guidelines being promulgated by the Supreme Court of India. In the year 1997, the Supreme Court of India observed in the case law of Vishaka versus State of Rajasthan, they set out certain guidelines. Before setting out those guidelines, the Supreme Court said that sexual harassment of women at workplace is a clear-cut violation of Article 14, Article 15, and Article 21. So do Article 19(1)(g), that is, to practice any profession or to carry out any business, trade, or occupation. So, sexual harassment of women at workplace is not only the violation of the constitutional rights but also the violation of human rights, so which needs to be addressed. Hence, the Supreme Court of India, way back in the year 1997, said that these guidelines which are being given in this aforesaid case law will be enforced until the suitable legislation which is being rolled out by the parliament of the country in subsequent years. So in the year 2013, the parliament of the country has drafted this legislation, that is Prevention of Sexual Harassment of Women at Workplace, and which is came into force on December 9th, 2013. So in this particular video, we are going to discuss what are the objective of this act, and if anybody is subjected to any acts of sexual harassment at workplace, then what are the remedies they can seek for, and how to address the same, and how you can redress the same, and what are the remedies you have, how you can raise the complaint, how you can redress the same, and among the other things. So we are going to discuss whether this act is applicable to men as well or not, whether the man is considered to be the aggrieved person or not. So among the other things we are going to discuss, and this is a most important video in order to get the awareness about the prevention of sexual harassment at workplace. So protection of women at workplace is a very important aspect, and it will uphold the interest of the women, the interest of the society, and interest of the country at large. So do the interest of the organization or the enterprise. Since we were discussing about the prevention of sexual harassment of women at workplace, let us understand in the very first place what is the meaning of sexual harassment. Sexual harassment means any unwelcome act or behavior. You might think the sexual harassment should always be the physical. No, the answer is no. So sexual harassment can be either verbal, non-verbal, or physical. So it can be among the any other thing. So any other sexual colored remarks, sexual advancements, and showing pornography, and demand or request for sexual favors, all of these constitutes sexual harassments. So to conclude, what exactly sexual harassment constitute? It can be anything which can be verbal, non-verbal, or physical unwelcome act or behavior. So these are the components which constitute sexual harassment. If one go by this definition, they can understand whether they are subjected to sexual harassment or not. So even showing pornography is also sexual harassment. It doesn't have to be physical always. So this is a definition of sexual harassment. Since we have discussed about the definition of sexual harassment, now we will examine what are the consequences of sexual harassment. As we all know, the 21st century is known for the women workforce. So if there are any consequences of sexual harassment, then it would impact the women, the organization, and the country as a whole. So the productivity of the workforce will get decreased by the sexual harassment. So there are certain consequences which can be detailedly discussed here under. So emotion and psychological consequences that will impact the productivity of the working women, affects the career, the ability to work. So in order to climb up the hierarchy, she needs to be having the sustainable working career. However, the consequence of sexual harassment will hamper her career and ability to work, interferes in private life, creates anger, hostility, and among the others. And finally, a decrease in motivation to work. If any woman is subjected to sexual harassment, it will decrease her motivation to work. So, these are the consequences of sexual harassment. Not only impact the women but also the organization and country as a whole. Hence, the sexual harassment needs to be combated. As we were discussing about the prevention of sexual harassment of women at workplace, let us understand what is workplace. So does it have to be the organized sector? Can it be the unorganized sector? Would it be applicable to NGOs? Would it be applicable to hospitals, charitable funds, charitable trust, or among the other things? What constitutes workplace needs to be understood in the very first place to get protection under this act. So there are certain components which are considered to be in the nutshell to define what is workplace. So let us examine each one of it in detail. So dwelling place or house or any other unorganized sector, department, organization, undertaking, etc. of government, sports institute, stadium, sports complex or competition or games venue, hospitals or nursing homes which are inducted into the service sector, society, trust, NGO, and service providers. So these service providers are being defined under Domestic Violence Act. So private sector organizations, ventures, undertakings, establishments, enterprises, institutions, and among other things, any other place visited during course of employment. So this is a very important point among all other points. Any other place visited during course of employment. So it doesn't the have physical to be office where the woman has been working. If she is being sent to any other place during the course of employment, and if she is subjected to any sexual harassment at that elsewhere place, then also the sexual harassment will be imposed. So that will be considered to be the women subjected to sexual harassment. It doesn't have to be in the physical office, it can be elsewhere if the woman is being sent there during the course of employment. So these are the certain components where it shares what is unorganized sector, what is organized sector, what are government departments, what are government organization, government undertakings, private institutions, sports, hospitals, any other place visited during the course of employment. These are the components which constitute the workplace. Who are protected under this act? In the beginning of the video, we were discussing whether this act is applicable to men or not. Whether this act is applicable only to the women. Among all other questions we were asking, and I said that we will discuss the same subsequently. So let us discuss whether this act is applicable to men or not. The answer is no. It is not gender neutral act. This act is applicable only to women. And the aggrieved women, we do have three types of aggrieved women. That is, women employee, any women who visits the workplace, domestic worker. So these are the people who are constituted to be the aggrieved women. So this act is applicable only to women, not to men. This is a shortcoming of the act, because not just the women but men also subjected to sexual harassment at workplace, as we were discussing about that 80 and 40 ratio. So men is also subjected to sexual harassment at workplace. So this act has certain shortcomings, and that is one of this. So this is not gender neutral act where the amendments is required, and we will see the eventual amendments in the days to come. Who can make the complaint of sexual harassment is a very important question and pertinent to our topic. Here, an aggrieved woman can complain in written if that aggrieved woman has incapacity due to mental or physical. Then his or her relative or friend or the co-worker or the officer of National Commission for Women or State Commission for Women, any person who has a knowledge of incident with the written consent of the aggrieved women, and if the aggrieved woman is incapacitated by mental incapacity, then the special educator or the guardian under whom she is taking the shelter or the care. So if the aggrieved woman is dead, then what is the solution? If the aggrieved woman is dead, then her legal hire can complain in written. If the legal hire doesn't come forward, and if any person who has a knowledge of the incidents, and then he can take the written approval from the legal hire, and then he or she can approach the internal complaint committee. So these are the people who can complain if any woman is subjected to sexual harassment at workplace. Let us discuss the redressal mechanism which is mentioned under this act. If any woman is subjected to any harassment at workplace, in particular the sexual harassment at workplace, she can approach either the local complaint committee or the internal complaint committee. So internal complaint committee is being constituted by the employer. If the employees are more than 10, then it is mandatory that every employer should constitute a committee known as internal complaints committee. So coming to the local complaints committee, every district officer will have to constitute a local complaints committee at the district level, and he will appoint a nodal officer in every taluka when it is in relation to the rural or tribal areas, and every nodal officer in ward or municipality when it comes to the urban areas. So these people will look after the complaints in those employer houses. So these people will collect the complaints from the employer and they will forward internal complaint committee. So let us will be headed by the presiding officer, internal complaints and not less than two members from amongst the employees, one member from NGO. So it will have four members. One is presiding officer, and two are from among the employees, and one member from NGO, that is outsider. Coming to the local complaints committee, it is headed by the chairperson, one member, and two members from NGOs, one ex officio member who has a knowledge of these aspects of the act. So this is a composition of internal complaints committee and local complaints committee. So these are the two committees which will look after if any woman is subjected to sexual harassment at workplace. Now we will discuss what are the penal provisions in relation to sexual harassment of women at workplace. So we do have these penal provisions which are enshrined or given under Indian Penal Code. So section 294, any obscene acts and songs at public place is a punishable offense. And section 354, that is any assault or criminal force used against women with intent to outrage the modesty of women is a punishable offense under section 354. And we do have 354A to D, which speaks in detail about the women. That is section 354A speaks about sexual harassment, and 354B speaks about any assault or criminal force used against women with intended to disrobe her. And section 354C speaks about voyeurism, that is capturing the images of women when she is involved in the private acts. And section 354D speaks about stalking, that is deliberately following the women despite of clear indication of her disinterest, and monitoring her emails and any other accounts which are in the nature of social media. And we do have this another important section, that is section 509, any words, acts or gestures with intent to insult the modesty of women is a punishable offense under section 509. So this is this is an important act in a nutshell what we have discussed till now, where we have given the definitions covered under this act and who are the aggrieved women and where she can approach in order to get her issues redressed. And we do have discussed about the complaint committees like internal complaint committee and local complaint committee. And finally we have discussed some of the penal provisions in relation to this act. So this is a very important video where we have discussed the outline of every aspect of the act if a woman is subjected to sexual harassment at workplace. So if you want any associate from our legal adapt to give the seminar on this topic at your organization, please do comment in the comment box. By that we do approach you for giving the seminar on this. And this has to be the national movement where the awareness needs to be spread across the country on this particular aspect, because 81% of the women are subjected to sexual harassment at workplace, and we need to address this issue at war foot. So you can ask us and request us, you can indeed let us know if you want any seminar from us, and we do give it for free. And we do want to promote this particular awareness to the women all across the country, and by that we can secure the safe and healthy environment to women to work at the work locations with all the without subjecting them to the sexual harassment at workplace. So thank you for watching this particular video. Indeed, it's honor to present this video. Thank you.